Have you considered how recent tax law changes may have impacted your estate plan? As tax law changes over time, it's important that you go back and review your estate plan and make sure that it's still doing everything that you want it to do, that you're not creating any unintended consequences because you didn't update the plan to match the current law. Your heirs are going to inherit under the current tax law regime. And so it could be important to make some adjustments so that your estate plan still works exactly the way you want it to work. Let me give you a couple of examples of what I'm talking about. One has to do with IRAs. Before the Secure Act and Secure 2.0, your heirs were able to receive their share of your IRA or 401k. They could set it up as an inherited IRA, and they could stretch that over their lifetime. They had to take a very small required minimum distribution from year to year, but they could stretch that out and defer that tax for the rest of their life. And because of the way that worked, we were able to actually leave the IRA to a trust for them that would provide some creditor protection and really ring fence it for them. And they could take that required minimum distribution. It would flow into the trust, flow out to them. They'd pay the tax on it, but that was a small amount of the total balance of that IRA. Under the new rules, that plan does not work. The new rules require that the IRA be distributed in full within 10 years. And for some, that could mean no distributions for the first 9 years and then the full thing in the 10th year. For others, it could mean that required minimum distribution for those first 9 years, it's still a small amount, and then the remaining balance in the 10th year. This doesn't work with the whole plan that most people had in mind, and it doesn't work so well with the trust anymore because at the end of the 10th year, it's all going to be distributed out. So if that trust was intended for creditor protection or other things, that's not going to work. There needs to be some changes to the way that the trust is written, to the way that the other legal documents are written, and to the way that the beneficiaries are set up on the IRA in order to carry out these wishes. The other area that I want to talk about is with credit shelter trusts. Before all of these tax law changes, back to the Tax Cuts and Jobs Act made some changes. Those have now been made permanent under the One Big Beautiful Bill Act. Before we had these new tax laws in place, it was very important to try to maximize the use of the lifetime estate and gift tax exemption. Estate tax, gift tax is 40%, so that's very hefty, and the exemption was much lower. And so one of the strategies was to use a credit shelter trust. Now that's just a fancy name for, this was this bucket where you could put as much as possible up to that estate tax exemption, set that aside at the first death so that it was already accounted for under the estate tax exemption. And then at the second death, it would go on to the heirs without being included in the estate tax calculation at that second death. And that helped maximize the use of how, the exemptions to get more assets to heirs without paying that 40% estate tax. But under the current rules, that estate tax exemption is over $15 million. So for a couple, that's over $30 million. And they've now added the ability to have whatever the first spouse doesn't use pass on to the second spouse. It's now portable. And there's some steps to follow in order to make sure that that gets locked in. You would need to work with your advisor on that. But that allows that couple to use the full estate tax exemption. Those limits have now been made permanent this year under the One Big Beautiful Bill Act. So over $30 million can go to your heirs with no estate tax, which means we're no longer worried for the most part about the estate tax. Let's say you have an estate worth $10 million. That's still quite a bit under $30 million. So now we're worried about how can we minimize the income tax Well, if we've got money that is going to go into the credit shelter trust at the first death, grow until the second death, and then pass to the heirs without a step up in basis, then we suddenly have created this income tax problem because we don't get that step up in basis. That means that the heirs are going to have to pay capital gains tax on the growth from the first death until the second death. And we don't want that. So we've got to be rethinking the plans to determine what is the best way to get the assets from first spouse, second spouse onto the heirs without creating any income tax problems or any estate tax problems. Now, you could live in a state that has their own estate tax. I'm just talking about the federal amounts right now. And so if you do live in a state with their own estate tax, you'd have to be looking at that issue. That would change the planning issues that you had to be addressing. But for anybody that is looking at the federal amounts, the thing to be looking at now is how can you structure your estate plan to minimize the income tax when you pass that on to your heirs. There are a lot of things that can be done. And if you've got some assets that are already in credit shelter trusts, you've got to think about, should we start figuring out some ways to use some of that, draw some of that down, and allow the assets that are still in the surviving spouse's name that are going to get the step up, allow those to grow more. How can you rethink the entire plan in order to maximize the value to your heirs and minimize the amount of tax that's paid, whether that is estate tax, generation skipping tax, income tax, whatever taxes you're facing, how can you minimize those? Now, as you're thinking through the changes that you need to make, in my opinion, it's always important to say, what is the simplest solution? What is the most flexible solution? And what are the other solutions? And why would I choose one of them over the thing that is simplest and most flexible? Because sometimes these things that make a lot of sense at the moment don't make sense down the road after the law has changed again. So you want to be sure that you have an understanding of the flexibility that you have in whatever plan that you put together. And with that in mind, you should be working with your financial advisor to think through all of these kinds of issues, as well as working with your attorney to understand what options you have under the law in your state, what would really apply to your situation. And if you have somebody that's doing your taxes, getting some input from that person as well. But have your financial advisor. That is a key person to help you understand all of the issues from a big picture view, how that's going to flow through your retirement plan and then on to your estate plan. That is something that I talk with my clients about on a regular basis. We're looking at the retirement plan and then what is the legacy plan and how do these decisions impact that and what is actually going to heirs or to charities or wherever we want that to go, what is going in the end, and how can we minimize all the taxes on that. With that, I hope that's helpful, gives you some food for thought, some things that you need to be thinking about to get your affairs in order to match the current tax law changes. If there are any questions that you have, feel free to shoot me an email and like and subscribe so that you don't miss any other things in the future. Look forward to seeing you in the next video. Have a great week.